Hello, everybody. Thank you for taking the time to participate in this webinar and presentation. What we're going to do is do a presentation here on the Indian Arts and Crafts Act. I will discuss some of the legal protections under this federal law for Native American artisans, as well as some of the shortcomings. Just to dive right in, Manahu, Inani Anna Hohag, Numanu, I hope no Kimadu. My name is Anna Hohag. I will be walking you through this presentation today, at least on mainly the details of the Indian Arts and Crafts Act. I am a member of the Bishop Paiute tribe located in Payahunadu, or modern-day Bishop, California, in the Owens Valley. I am a relatively new lawyer in the last 2 to 3 years, and very happy to have returned back to California to practice in my home state. I am currently with a law firm that practices Indian law, primarily with clients that are tribes in California, but also across the country. And we're out of the Sacramento office. We have a Rapid City office as well as a Washington, D.C. office. Today, what we're going to do is we're going to discuss the ins and outs of the Indian Arts and Crafts Act that was enacted by Congress. We're going to give some examples and case studies of, showing how this act has been enforced in the past. We're going to do a brief overview of other tools that you can use to protect your intellectual property. We're also going to discuss kind of like an overall impact of cultural appropriation in Native communities, and then end with some best practices for both Native artisans and sellers and buyers. So let's get started. Unfortunately, it is a problematic reality that fraudulent Indian arts and crafts compete daily with authentic Indian arts and crafts in the nationwide marketplace in the U.S. And this directly and negatively impacts the livelihoods of Indian artists in the U.S. as they are having to compete with essentially fraudulent Indian arts and crafts. And that's what really brought about the Federal Indian Arts and Crafts Act of 1990. And what this law does is it's primarily a truth in advertising law. It prohibits misrepresentation in the marketing of Indian arts and crafts products within the United States. So it does only apply in the United States, not internationally. And what it says is that it makes it illegal to offer or display for sale or to sell any art or craft product in a manner that falsely suggests it is Indian produced, that it is an Indian product, or that it is the product of a particular Indian or Indian tribe or Indian arts and crafts organization within the United States. And it actually comes with some pretty hefty violations, both civil and criminal. So beware to those out there. There are both civil and criminal penalties of up to $250,000 fine and even up to a 5-year prison term, or both. And that's for individual violations. If it's a business violation of the act, the business can face civil penalties and be prosecuted and fined up to $1 million. And yes, of course, the standing issue, who can bring a suit? An Indian tribe can bring the suit, an Indian arts and crafts organization, Indian individual, and the Attorney General of the United States can bring a suit on behalf of any of the three above. The Act defines Indian or Indian style. Indian is defined as a member of any federally recognized tribe or a member of any officially state-recognized tribe of the United States, or an individual who is certified as an Indian artisan by an Indian tribe. So we'll dive into that on the next slide on what does that exactly mean? Who does that leave out? The law covers all Indian and Indian style traditional or contemporary arts and crafts products that were produced after 1935. So here are some of the shortcomings of this definition of Indian. It only protects individual artisans that are enrolled members of federally recognized tribes or officially state-recognized tribes. So what does that mean in the context of California? Well, California doesn't have any officially state-recognized tribes, although we are aware that there are many dozens of non-federally recognized tribes in California that absolutely are tribes in California, but that do not have this official status of protection under the Indian Arts and Crafts Act. So that is a shortcoming. So for instance, if an indigenous artisan is from any of the one of the many non-recognized tribes in California, or is an individual of a descendant, or they are a descendant of a federally recognized tribe, but they're not enrolled in a federally recognized tribe, then they're not actually protected under this definition in the Act. So that is one major shortcoming in my opinion. So as we mentioned, the Act is a truth in advertising law. All products must be marketed truthfully regarding the tribal enrollment of the producers. So it does not mislead the consumer. And that is really the main heart of this law, is to protect both the Indian artisan, but also not to mislead or defraud the actual consumer, because this is a market in which the consumer is looking purposefully to buy an Indian-made product. So it is illegal to market art or craft work using the name of a tribe if a member or certified Indian artisan of that tribe did not actually create the art or craft work. And we'll see a case study on that. Also, the impact on the economy and the Indian arts and crafts market is profound, which is absolutely why this act was necessary. According to a 1985 study on imported Native American style jewelry and handicrafts, not Indian made, the estimated size of the whole industry was between $400 to $800 million. The estimated impact of unmarked imports were 10 to 20% of the total value of the entire industry of Native American arts and crafts. So that is a huge dent that is fraudulent Indian art. A study by the Government Accountability Office in 2011 stated that the size and extent of misrepresentation is largely unknown. Again, this consumer fraud misrepresentation erodes the overall Indian arts and crafts market and the economic and cultural livelihood of actual Indian artists, craftspeople, and tribes. So this has a direct and negative impact on people's livelihoods. Also, the Indian Arts and Crafts Board, just to state a few things about the board, they are essentially the enforcement wing of the Indian Arts and Crafts Act. They're an agency within the Department of Interior that was created by Congress, technically to promote the economic development of federally recognized American Indians and Alaska Natives through the expansion of Indian arts and crafts market. They implement and enforce the act. They provide professional business advice, fundraising assistance, promotional opportunities, and they also produce a consumer directory of Indian artisans. So any Indian artisans that are listening to this webinar and paying attention, if I were you, I would, check out that website. They actually do have some opportunities that you can advertise your work or become a part of this consumer directory. If you are aware of a potential violation, you can also contact the board and report this violation online. And just briefly, these are the federal laws and regulations that pertain to this act, to both the civil and criminal aspects in the U.S. Code, and then the regulations, and just the federal regulations that really expand on the act. All right, so we're going to dive into some case studies and examples. The first is Pendleton, a very well-known company that produces a lot of Indian-style tribal-looking designs on wool blankets. I'm sure you've seen these everywhere. They're pretty popular in Native communities. I'm sure nobody is shocked. They offer imported Sioux Star quilt, Lakota dinnerware, Sioux Star blanket, and several other items, which make an unqualified use of tribal names through its catalog and in the Native American section on its website. Because of this, the Indian Arts and Crafts Board and the Department of Justice contacted Pendleton regarding this unqualified use of these tribal names and terms in their marketing and advertising practices. And essentially what happened, the outcome there was a settlement in which Pendleton donated money to an Indian school in South Dakota. They removed all misleading terms on their website and catalog, and they also agreed to add information about the Indian Arts and Crafts Act to both their catalog and website. And so now if you look at their website, they have a Native American inspired section. So that must have been enough to appease the Arts and Crafts Board in that instance. Another case study example has to do with this large luxury retailer, Nieman Marcus, and the image of the actual design artwork at issue is pictured here to the right. And then Nieman Marcus was selling this essential copycat of the art there, as you can see, as a coat. So the facts of this case study, the Alaska Heritage Institute and Native American or Alaska Native Organization sued Nieman Marcus for selling this coat that you saw to the right for about $2,500 nonetheless. But it contained this very cultural raven's tail design that was essentially copied from a raven's tail coat created by a Tlingit weaver nearly a quarter century before. The organization claimed that the retailer violated the Arts and Crafts Act and copyright law. And the Raven's Tail term and style has been associated for hundreds of years with the Tlingit, Haida, and Tsimshian tribes. Something interesting, and this really brings in this copyright issue, is that when the original Tlingit weaver and artist passed away in 2016, her family actually obtained the rights to the robe, the actual original cultural robe, and registered the robe with the U.S. Copyright Office. In turn, this copyright was then exclusively licensed to the organization Alaska Heritage Institute. So they were able to sue Nieman Marcus, both in claiming a violation of the Arts and Crafts Act as well as copyright law. Another example is this Peter Stone Company. They were essentially an international jewelry wholesaler selling knockoff Indian jewelry entitled the Wolf Walker Collection. They advertised the Wolf Walker Collection as authentic Native American jewelry and Native American designed at both trade shows and on their website. The designer was not Indian, as defined under the Act, and the jewelry was mass-produced with stickers on them that actually read "Made in Thailand." Another case study is United States versus 99,337 pieces of counterfeit Native American jewelry. This particular case, I wanted to start with a quote from the U.S. attorney that brought this suit. In New Mexico, he stated that imported trinkets as authentic Indian jewelry undermined New Mexico's vibrant market for traditional Native artwork. And this really stresses the point that these counterfeit, knockoff, arts and crafts, Indian jewelry, that are imported from places like Thailand, they really do make an impact on both the market that is there for Indian artisans and the actual lives and livelihoods of these people. The wholesale jewelry in this case was both out of Albuquerque, New Mexico and Gallup, New Mexico, where they were being sold. The products were imported from the Philippines and could have reasonably been mistaken for authentic Indian-produced art. Some products also claim falsely to be the initials of Navajo artisan. So this is an example of fraudulent advertising in that they were claiming to be authentic made art, authentic made jewelry, to the point where they even, falsely etched in initials of what they claimed was Navajo artisan, which was false. All in all, 350,000 pieces were seized, with a potential value in the marketplace that exceeded $35 million, which is a huge chunk. There was this interconnected business in several states across the Southwest and in the Philippines. 2 men ultimately pled guilty of violating the federal law and face up to a year in prison. As far as the businesses themselves, they have agreed to serve 5-year probation and to pay $300,000 to the Interior Department's Indian Arts and Crafts Board. All right, so this is another example, and that is Urban Outfitters. Here to the right, it's a couple of the photos that are examples of what we will dive into. So the Navajo Nation sued the clothing retailer Urban Outfitters for using the term Navajo to describe at least 40 items that they were selling on their website or in their catalogs, including, as we see here on the front, underwear and a flask. Urban Outfitters argued that the term Navajo was actually a generic term, so that was their defense. Navajo Nation actually holds nearly 90 trademarks using the Navajo component, and the nation made a concerted effort to protect the nation's culture, image, and the livelihood of their artisans. And I believe that case was getting settled. Another example was United States versus Haack. This one's really interesting. Essentially what happened was there was use of an online marketplace by an individual who was both marketing and advertising jewelry and accepting online payment for this jewelry, which both he claimed was Indian jewelry, Indian made, and falsely misrepresenting that it was made by this Hopi artisan, Charles Loloma, who had actually already passed away. So in this case, which is ongoing, the U.S. attorney charged Robert Haack of Los Angeles, California, with violating the act by fraudulently creating and selling jewelry online. He was charged with 2 counts of wire fraud, 2 counts of mail fraud, and 2 counts of violating the Indian Arts and Crafts Act. If convicted of these charges, he faces a statutory maximum penalty of 5 years in prison and up to a $250,000 fine. So this again is ongoing, likely because of the pandemic. It will continue to be ongoing. And this image here is the actual image of the late Charles Loloma, a renowned Hopi artisan. So let's just briefly cover a few of the other potential protections beyond just the Indian Arts and Crafts Act. We'll touch on the federal, Trade Commission, copyright law, trademark laws, state laws, custom regulations, These are other avenues that Indian artisans may want to look into to protect their arts, their crafts, their intellectual property. So what is intellectual property? Intellectual property, you might also hear it as IP for short. It's a catch-all term that refers collectively to anything that you create. For example, the following are all IP: trademarks, copyrights, patents, trade secrets. Also, indigenous designs are all forms of intellectual property. Really briefly, copyright, it is a legal right to use the original literary or art and artistic creation. It can include sculptures, fabric designs, paintings, baskets, and music. It gives the owner the exclusive legal right to reproduce, publish, sell, or distribute artwork. It allows you to control how your creations are used by other people, and a copyright lasts for the life of the author and the creator, plus 70 years beyond that. So it is essentially an exclusive right to use, to produce, to publish, to sell. What copyright can do is it can stop others from making new works created from your original artwork without your permission. It can protect, copyright protection begins from the very moment you create your artwork, and it does not require an official registration. However, they do recommend using the C symbol along with the year and name of the owner of the copyright, just to put other people on notice of your rights. You'll notice that symbol. Now that you've seen that here, you'll start to notice it everywhere. However, registering your copyright with the Copyright Office does provide other avenues to protect your art. And that includes, these advantages like the ability to sue for copyright infringement, to collect royalties, and to enforce rights outside the court. Let's touch on trademark really briefly. It helps the consumer identify and distinguish your goods and services from those of others. It can be things like letters, words, slogans, symbols, designs, colors, product, packaging, configurations, sounds, or scents. Trademarks can exist forever, as long as they're being used in business. Trademarks are used to prevent other people from using a similar mark. You can register your trademark, although it is not required, but it does provide certain legal advantages, like allowing you to file suit in federal court against trademark infringers and unauthorized users. Registration provides legal proof showing the court that you own the mark. It puts other people on notice of your trademark rights and also bars them from registering similar marks. What registration also does is essentially just protect and put others on notice so they know that this is your original creation. And what you can do if you do want to register is you want to submit an application with the U.S. Patent and Trademark Office. And once you do that, once it's accepted, you can use this R symbol with your trademark. But in the meantime, before it's registered, you may use the TM or SM symbols. A design patent, this protects the way an article looks. It gives you the exclusive use of a new and original design on your products, like on jewelry, pottery, or textile design. A patent gives you an exclusive right to use your pattern or patent design and prevents others from producing, importing, selling, or distributing products that infringe your design. A patent must be applied for from the U.S. Patent and Trade Office in order to sue for infringement. A patent application must be filed within 1 year from public disclosure of your patentable design. And a patent typically, it will last for 14 years. IP on the internet. So this is, really relevant in this day and age where so much is on the internet, whether that's the marketplace, both for consumers and sellers. The design and content of your website, including a domain name, may implicate a variety of intellectual property issues. What do you do if someone uses your intellectual property without your permission? Well, because of IP rights, because they are private rights, you must take affirmative steps yourself to enforce your rights. Nobody is going to enforce your rights but you. Enforcement options include lawsuits for infringement, obtaining a court order to stop the sale or importation of infringing goods, as well as money damages. If you believe your work has been used in an unauthorized manner, what you should do is you should consult with an IP attorney who specializes in intellectual property. And for any more information, I highly recommend checking out the Indian Arts and Crafts Board website, as well as the U.S. Patent and Trademark Office, as they will have many resources there for you to look into. And they also have other publications free for download. Trademark law and cultural appropriation. So how is this all tied with how it impacts our communities? Well, over 600 active trademarks exist from 450 companies that have Indian mascots or use Indian imagery in their branding, majority of which are non-Indian owned. For instance, appropriating indigenous traditional knowledge is very persistent. There was an instance where Aveda was working to trademark the word indigenous, but after facing backlash from indigenous communities from all over the world, they withdrew that trademark application and instead went a route that included benefit sharing with indigenous communities for the types of products that they were actually using in their beauty products. Also, pharmaceutical industry and beauty industries to this day and throughout, their history have been exploiting traditional indigenous knowledge for profit, really not providing any benefit to those indigenous communities where that knowledge originated from. Also, this idea of mascots. There was a lawsuit against the Washington, D.C. football team in an effort to cancel their team's offensive mascot and team name under the trademark, or to cancel the trademark under the Lanham Act. That did not go over well simply because in a separate case, the Supreme Court invalidated the Lanham Act, the provision that would have allowed for this cancellation for offensive use. And then finally, indigenous designs. I'm going to touch on, how indigenous knowledge or indigenous contemporary or traditional art and craftsmanship has been essentially copied by modern or by, mainstream fashion and high fashion. So here's an example of the Washington football team and their offensive mascot and team name. Here's the example of this fashion knockoff here of an indigenous woman fashion designer, Bethany Yellowtail, and her inspiration she drew from her grandmother's artwork. And then all the way to the right is the knockoff of her work that was seen on a high fashion runway in a different country. Another example of how traditional artwork or art and craft work was used and exploited by high fashion. The two outside images are of a Inuit design, a Nineveh family sacred Inuit design that had been in their family for generations, and an image here from a fashion show where they quite clearly just copied this design. Also, stereotypes of Native Americans. This type of cultural appropriation and this Indian imagery that is used throughout not only the United States, but throughout the globe really reinforces stereotypes of Native Americans. They're reinforced through misappropriation and mascot, and they depict Native people as figures of the past. They typically wear headdresses or war bonnets, feathers, tomahawks, teepees, caricatures, essentially depicting us as non-humans, but of cartoons, and then really depicting this romanticized and exploited image, for the past 200 years. So these really do have negative connotations for Native people and real impacts to Native people's lives. So why does this matter? Why does representation matter? Why is it that actual Native American artisans should be representing Native people in their arts? Well, promoting Native American artisans, their arts, and products ensures that Native Americans are self-represented. We are not a stereotype, although stereotypes have dominated mainstream American culture. They really do impact the ways that laws are interpreted, policies are made in our country. People's perceptions of Native people via media, via cultural appropriation and Indian imagery really does impact the public's interpretation and idea of us as human beings or not human beings. And finally, representation matters because Indian artisans really can contribute to tribal economies and a larger market worldwide. And I just briefly wanted to touch on a couple of international laws that touch on this issue. The United Nations Declaration on the Rights of Indigenous Peoples, Article 31 states that the right to maintain, control, protect, and develop their intellectual property over their cultural heritage, traditional knowledge, and traditional cultural expression. So this is a right that is defined under the UN Declaration for Indigenous people, as well as the World Intellectual Property Organization has some pretty timely information and protections for Indigenous people, although still working on that and there. They found that there is an increased demand for protection of traditional knowledge systems from Indigenous people. They have established an intergovernmental committee on intellectual property and genetic resources under traditional knowledge and folklore. And some Indigenous communities around the world are getting very creative in protecting their intellectual property and traditional knowledge systems. And this is a brief video that I thought would be interesting just to bring to light to anyone watching this webinar on how some tribes are doing that. I will recommend to the organizer to pass this link along to everyone who participates. So finally, what are some recommended steps to either shop or promote your goods wisely as Indian artisans? When purchasing or selling to a dealer, make sure you choose one with a very good reputation. Make sure you request or provide written guarantee or written verification of authenticity. So if you are a consumer, make sure that either you would request this written proof and verification of authenticity, or if you are a seller, make sure that you provide that, because consumers really are looking for that authenticity. Make sure you get a receipt that includes all the vital information about your purchase, including the price, maker's tribal affiliation. And when selling a product, advertise. Make sure you do this. Make sure you advertise and promote all of this vital information about you, including your name and tribal affiliation. Again, consumers are looking for this. And finally, familiarize yourself with different materials and different types of Indian art and craft work, as well as the indicators of well-made handcrafted pieces, just to ensure that you are not being fooled by any means. And I would also recommend checking out the Indian Arts and Crafts Board website. They can help you advertise your work. They could add you to a consumer or producer list, and I would definitely start there. Thank you. I was hoping to make this much briefer and just a very quick overview. Lastly, here's the website for the Indian Arts and Crafts Board. I think there's plenty of resources on the website. I encourage you to check it out. And I wanted to end with some California native specific images. The middle one of a Karuk, Hupa, and Yurok artist, Lynn Riesling, whose art I admire. And then over here to the right is a yoga basket design that will be featured on a license plate in California. And with that, I hope you enjoyed this presentation. I know it didn't dive too much in depth, but I wanted to provide a brief overview. And I hope everyone is staying well and safe during this pandemic. And I hope you were able to learn a little bit of something new. Thank you. Manahubu.